file a lawsuit, and then we're going to see if we're going to rule in your favor or not. And I said, no. I have the authority right now under the Constitution to do exactly what we just said. If you want to stop me from doing it, then you can file a lawsuit and explain to everyone how the 7th Amendment does not exist, and the 10th Amendment, which is my authority to do that job if you don't do it. Okay, the 10th Amendment, you can't overstate how important it is. Okay, if you go back to the document, the 10th Amendment, it says the government has discretion, and the word self-effectuating is the key to this whole concept. The government is not, you have the right to free speech. The government is not required to give you a computer to get on this thing here with Bran tonight. But you have the right to talk and to listen to other people talk. That's free speech. But the government, most of your rights are self-effectuating. The government's not required to provide you a firearm. They can if they want to, but they don't have to. So if they don't provide you a firearm, it's your job to go down to the gun store and buy whatever you want. It's not the government's job to effectuate most of your rights. Almost all of your rights are not, they are self-effectuating. And the 7th Amendment is that, because it doesn't say anything different. And also, the 10th Amendment says, everything else not given to the federal government is reserved to the states or to the people, respectively. The people, those are the two words, the magic words that are in the 10th Amendment. And the word respectively. In other words, the state can give you a jury in family, civil, probate, any of these courts. They're not prohibited from doing it. Go through any of your laws, go through any federal laws, go through rules, state rules, federal rules, whatever you want. Rule 38 and Rule 39 of civil procedure, you'll find there's going to be juries in most states and in the federal civil rules. And it just, all it says is you have the right to a jury. That's all it says. And it has nothing else there. Okay, and so that's the swindle, that's the fraud that's being perpetrated on the American people right now, is that we don't have authority over the decisions being made in these courts because they simply say, we're not going to give you a jury, so forget it. And then people turn around and they go, oh, well, I guess I can't have a jury. Whatever the judge does is whatever the judge does, and I have no recourse. Or, yes, you have recourse. Did you waive your right to a jury? Most people, 99% of the people, the answer is no. Okay. So, you know, if you get on your phone, can you find 6 or 8 or 12 people that could serve on a jury? In other words, what's stopping us from effectuating our own rights when it comes to providing a jury in these courts? The answer is nothing. The idea that's in your head that you can't do it is the only thing stopping you from doing it. Okay, so then what we've done is we created a company to provide that service. That's We the People Court Services. And this is the notice that we're sending out to everybody. And then I'll just read it to you. I don't see it on the screen. Fran can put it up there if she wants or not. Supporting authorities are state statutes, number one.
You talk about right here?
I'm sorry?
You talk about right here, or what do you want me to, it's, the screen's open, what do you want me to show?
Well, I'm looking at section 2.
Okay, am I in the right spot? Right here, too.
I'm not seeing it on my screen. Is it my malfunction here? I don't know what other people can see.
Okay, hang on, it might be me. Hold on, it's me. I don't know what I did. Hang on. Can't find it.
Because I have it in front of me, I can read it off to people. You know, this is really simple stuff, actually. This is not rocket science. And, oh, by the way, I don't need to cite the Magna Carta or, you know, the Virginia Declaration of Rights or anything, because I got everything I need in the Constitution and everything I need in the law and in the court rules to do exactly what I'm doing. Because when you go through the rules of family law and procedure in Arizona, at least, or you go through, oh, there you go. That's it. Perfect. You got it. How'd you do that? You're a genius. Okay. So we're looking at state statutes. There's no law that prohibits juries in these courts. See, it's not what's in the law. It's what's not in the law. is what matters here. Okay, even if there was a prohibition, it wouldn't be irrelevant because the Constitution says you have the right to a jury. That's one of the reasons there is no law otherwise. It's because the Constitution prohibits such a law. Federal state rules of civil procedure. Like I said, Rule 38 and 39, it basically affirms that your rights are inviolate. It doesn't tell you the step-by-step how to go about getting a jury or asking for a jury. It just says your rights are inviolate, and then they shut up. Okay? And family, juvenile, probate, rules of procedure contain no prohibition to a jury. Now, this is Arizona. There may be exceptions to that. In other states, there probably are. But if you have any statute or any rule that's contrary to the Constitution, it's invalid. It doesn't even mean anything. Okay, so go ahead, pass a law, make a rule. We don't even care because the Constitution is the supreme law of the land. Okay, and we're going to get to how this is enforced because supreme law of the land is the heart of it. Federalist 83 is important because it says in there that juries are the check on the power of civil courts intended to prevent corruption. Okay, this is a big deal. This is Hamilton. This is part of the discussion that was going on at the time they ratified the Constitution and the Bill of Rights. Okay, and because states were saying we will not sign up for another King George, forget about it. And Hamilton in Federalist 83 said the purpose of the jury is to prevent corruption. So here's the big question for all the smart people out there. If we allow judges to take juries out of these courts, what do you expect you're going to get? Corruption. Okay. Hello. So I'm just pointing out that there's a lot of ways to deal with corruption. Okay. We can start our own court system. We can put all judges in jail. We can put juries. The founding fathers pointed to the Seventh Amendment as the check on judicial power in these courts. And Federalist 83 says it in black and white, okay? And then there's case law. Now, this is important because they say, oh my goodness, case law, you got to follow case law. Absolutely, yes, we should. And there's two big pieces of case law that are out there. One of these is SCOTUS, okay? And the other one, I think, is a state Supreme Court. And they're listed here. You got Minneapolis and St. Louis v. Bombolas. Okay, you can call it up and look at it if you want. Then you got United Gas Public Service v. Texas. Okay, and both of these pieces of case law affirm the court's discretion to furnish a jury under the Seventh Amendment. And so you can go into both these documents and you can word search the documents and you will find Seventh Amendment. One of them has in there 17 times. Seventh Amendment, yep, yes. And then both of them say the states have discretion to give you a jury or not give you a jury. They both affirm that, okay? Now, when you do a word search for the 10th Amendment, 0. It's not there. So no place in those two pieces of case law is your right to a jury diminished, or that you're not allowed to provide your own. Okay, so your handcuffs are off, have been taken off by these two pieces of case law. You're supported by case law. You're supported by Hamilton and the Federalists. You're supported by your own rules. You're supported by state statutes, which there's no prohibitions, and then your rights are free and clear under the Seventh Amendment and the effectuation of those rights under the 10th Amendment. If the judge doesn't want to give you that option, then it's your job to provide your own. That's it. Okay, and Hamilton says that's what you're supposed to be doing. Okay, so that's the reason I'm going down this rabbit hole. Okay, now if you want to scroll down, I don't know if you're still there. You want to scroll down, that's jurisdiction. Okay, here we go. Yeah, all right, here we go. So now, We the People Court Services, which is, well, that's a company that we set up to provide juries, okay? The basic concept is that if you have the right to own a firearm, but it's your job to furnish your own, well, you're not going to make your own gun. Nobody makes their own gun. That's too much work. It's too complicated. Okay, so where do you go? You go to somebody, that's their job. They make guns, and some people make really good guns, and you buy one of their guns. That's what you do. Okay, same thing holds for a jury. And there's nothing stopping me from saying, okay, we're going to provide juries, okay, and we're going to declare our jurisdiction is under the 10th Amendment. We prefer a bench trial because it's efficient and justice is usually rendered without intervention. Okay, in other words, we're not putting a jury in all 5 million civil cases every year. We're not going to do it. We can't do it. It's impossible. Okay, but we are going to have the final say over, you see item 3.1 here, unjust infringement on parental rights and familial rights. And there's going to be a presumption of shared parenting. That addresses family court. Okay, we are declaring our jurisdiction as number one going to be that. Number two is going to be unjust taking of property or money by judicial order. Okay, so when they say we're going to take all your money, we're going to garnish your wages until you die. Okay, it's like, you know what? Well, it doesn't sound like justice. I think I want a jury. Okay, and then the last one here is unjust or excessive incarceration or detention. Now, we've all dealt with that now, haven't we? Okay, we've seen that happen. Okay, and so we're going to throw you in jail till you pay the money. Really? I think I want a jury to make a decision on that. Okay. So then 3.4 is at the court's discretion, the people, us, may furnish their own juries in a scheduled court hearing or otherwise per rules established by the people to best preserve their due process. So in other words, we give the courts all the discretion we can. We say, first of all, just give us a good verdict or give us a good order, and we don't have to even talk about a jury. That's victory. Okay? If a judge knows he has a potential jury coming in there and examining his orders and probably overturning his orders, you got a whole different judicial system now that you're dealing with. I'm just saying. Okay? Anybody who thinks that that these judges will perform the same when somebody's looking over their shoulder, the jury doesn't have to be in the courtroom to have an effect on that court proceeding. Okay, just the idea that we have the final say over all these bench trials will mean that instead of a 40% failure rate, we might drop down to like maybe a 5 or maybe 7% failure rate. Okay, and then we're going to have final authority over those. Okay, so in other words, most of the problems disappear simply because the judges don't want to have to be second guessed. Right now, they can do anything they want and they can get away with it. Okay, that's what's different with the 7th Amendment. Okay, then number 3.5 is we have the discretion to provide or not provide a jury based on the merits of the cases. Okay, so in other words, if you have something crazy or not applicable, like we had one lady, she was ordered to pay $1,500, and she wanted a jury for that, and we told her no, because we're going to charge you, more than $10. We're going to charge you a significant fee, and then we're going to screw around with this damn thing for $1,500. We declined to take that case. Okay. Anybody who's had their kids taken away for no damn reason, we take those cases. Okay, normally. So now scroll down to the next page. It's only a 2-page document. And you're going to get to section 4. Okay. And I don't know if Fran can still hear me, or I trust some people can still hear me. But I'll just look at section 4 here, and it says limits on the power of a jury, because everybody has to have the whole idea behind checks and balances is that nobody has unlimited power. Okay, and so for our juries, the ones that are not in the courtroom, okay, if the judge forces us to have a jury examine the evidence outside the courtroom, then that's what we'll do. And then if that happens, we're going to say that our juries do not have the authority to change the order or to, in what would be in effect, to make law. Judicial order is making law. We're going to say, but they do have the authority to strike down a judicial order and say, here's what we think it should be, give advice to the court. And then the judge gets to start over again. Okay, this is what the judges don't want. Okay, this is why they're going to pay attention when they're doing their, when they're issuing their orders in the first place. Okay, and so then the first option the judge has is to do nothing if, because juries sometimes will affirm the judicial order. We don't control what juries do. They either get to affirm or strike down the judicial order. Those are the two options they get. They don't get to change it. Okay. And so then the judge, then his first option is he can schedule a hearing with his own jury under his own rules. No, there's nothing stopping him from doing that. If you're there, Fran, do you want to scroll down to the second page? Or is that not doable? Maybe I can do it. Oh, no, I guess I can't. Sorry. Okay, but I'll just go through it. It's not a big deal. The second option is the judge can revise the order to conform to the jury verdict or to the wishes of the parties, and then the case is over. Okay, the third or the fourth, the next option is the judge can, and this hasn't happened yet, but we're coming up on it, is a judge can defy a jury verdict, which is guaranteed under the Constitution, which would create a breach of the Supremacy Clause and his oath for Article 6, Clauses 2 and 3. Okay, so we're back to the Constitution again. We're not citing anything outside of that. We don't need to. Okay, and the Constitution, once these people swear an oath, and this holds for anybody, it's an employment contract. That's what it is. Okay, so if a judge, the judges are not required to be a judge. They can resign anytime they want. If they define a jury verdict, if they say, I'm not going to recognize the jury verdict, I'm going to do whatever I want, I'm King George. You say, okay, you're no longer a judge. And at that time, our company, We the People Court Services, we notify the governor that the judge has resigned and he needs to appoint a replacement. And then after that, we notify the president to make sure that he does not appoint that judge to a federal bench, because he's defied the Constitution. He's resigned his position as a judge in the state court. So why would you even consider him for a nomination in the federal bench? Okay, and then finally, we put up on our website, we add him to the list of judges that are no longer, we call them juris non grata. You're no longer a judge in the state of New York. You no longer have the authority to exercise judicial powers in the state of West Virginia, or in the state of Florida, or the state of Arizona, or wherever you happen to be. Okay, this is the authority that we have over these people. Now you can say, well, we can impeach them, we can throw them in jail. Okay, yes, you can, but can you do that every single time when it needs to be done? That's your problem. Okay, if we give a jury verdict to a judge and he says, I'm not going to follow it. Okay, well, then I'm sorry, you're not a judge anymore, and here's what we're doing about it. Okay, so we're going eyeball to eyeball with these people. Okay, and that's pretty much the extent. There's another paragraph here that says how easy everything is, and so on and so forth. Thank you for being a great judge, and that's the extent of the rules that we're giving to. They're not that complicated, okay? But there's section 4. So you see the limits on the powers of a jury is they can either strike down or affirm the judicial order. If they strike down, if they affirm the order, the judge does nothing. That's 4.1. If they strike down the order, the judge, number one, he can schedule a hearing with his own jury if he doesn't like the verdict that we came up with. And this is where their arguments all fall apart. Is they say you can't have a jury because of blah blah blah. You say you're right. Go ahead and have your own jury, and then our authority disappears. Okay, that's what the 10th Amendment says. The state has the first bite at the apple, and after that comes the people. But nowhere does it say we don't get a jury. If we want one, we get one way or the other, and you get to decide what that is. Okay, they have discretion. After that, he has discretion to revise the order. In other words, say that he enters an order to take the kids. Take the kids. There's dog poop in the backyard, so you got to take the kids and protect them from the dog poop in the yard. Okay, let's see what a jury thinks. The jury strikes down the order and says, you know what, that's not enough. Give the kids back unless you can come up with some compelling reason that they have to be taken away by CPS. The judge has discretion to revise that order. Okay, we've already seen that once. Okay, in other words, they're trying to avoid this as much as possible, but we've already seen it once because the guy he said, well, I'll just change the order. Who gives a shit? Okay, this is only a one-time thing, and I don't have to worry about it. So they're already, this process is already starting to work. Okay, and then number 4, if he defies the jury verdict, then he's forfeited his authority as a judge. That's what 4.4 says. Okay, and then after that, we ask the governor to appoint a replacement, and then we notice the president to avoid federal appointments, and then we put his name up on the website he's not even a judge. Why would you go to his courtroom? You have to be nuts. Okay. And number 5 is just, other details that are just in closing. But that's pretty much the extent of the entire business model. Okay. And it's a business model that's the foundation of it is the 7th and the 10th Amendments. So is there anybody has questions, or do you want to go a different direction, or what's feedback on this thing? I see there's people here. I see people. So I also sent Fran some other documents on.
Hang on, I'll get them too. Just bear with me.
That's fine. Because there's all different ways to skin a cat. Okay, you can say I want a jury. You can give me one, or else I'll provide my own. That's one way of doing it. The other way is for your state legislature to provide juries, and any of these courts are not prohibited. Okay, if the legislature says you shall provide juries under these circumstances, okay, then there's nothing saying that that's an illegal law. Okay, so that's SB 1294. So you can see the model that we're pushing here. We're not talking about putting juries in every single case, because there's 5 million cases a year. Okay, forget it. It's impossible. But we are going to put them in the cases where it's like, number one, it has to be important. And another one, it has to be just an egregious violation of people's rights. Okay, and taking children, well, that has to be on the list. Taking all your money, garnishing all your wages, that has to be on the list. Okay, and it is. It's read due process. Tell me what due process.
Yelling you for protecting your children from domestic violence has to be on the list.
Agreed.
Taking your children because you protect them from domestic violence, imagine, and giving children to a perpetrator with a criminal history, and then accusing the innocent parent, the protective parent, the providing parent of doing something wrong. Agreed.
And so here's what I'm going to tell you, is that we have discretion to accept or to reject any case that comes before us. Okay, in We the People Court Services. Now that individual person can go out and do their own. Nothing's stopping them. Okay, but we're trying to stick with due process, as close to due process as we can, and we want to motivate judges to do the right thing in the first place, so we don't have to touch nothing. Okay, that's the big point here. Okay, the bench trial is efficient unless there's corruption. Okay. I think we all don't like corruption. That's why we're all on this video here today, is because there is corruption. Okay, unchecked judicial power guarantees that you're going to have corruption. I mean, it's just like you know, is the sun coming up in the east kind of thing. Okay. So here's the way we attacked it. If you go up to the top, there's two statutes in Arizona statute, and it's probably very similar from state to state. Okay. This is statute number 2. We can talk about this one here because we're here. Okay. This is the hearing that takes place, and this is CPS specific now. We're not talking family or probate or anything here. Okay. But keep in mind, the problems that exist in family, and the problems that exist in probate, and the problems that exist even in civil courts, and especially CPS, juvenile dependency courts, whatever you want to call it, they all the root of those problems is they've taken the will of the people out of the system, and they're able to do whatever they want. And when there's money involved, guess what? Okay, they're going to figure out a way to get the money. And if they have to kidnap your kids to get Title 4E money, that's what they're going to do. And if there's nothing stopping them, okay, and the check on their power is us through the 7th Amendment, our authority over them through the 7th Amendment. And this is actually a secret they're keeping from you, okay? Everybody understands what the Miranda rights are, the Miranda decision, okay? Because on the criminal side, okay, you have the right to a jury. If you ask for one, they shall provide it. They have no discretion on criminal, okay? And so what was happening on the criminal side was they just wouldn't tell people. And a guy named Miranda, who was an illegal immigrant, okay, and this is an Arizona case, he went and just said a whole bunch of stuff that got himself convicted of, you know, life sentences for everything, okay? And then it turned out that he didn't even know that he had the right to remain silent, okay? All he had to do was shut up, and then it would be the burden of the state to prove that he had done something wrong, okay? So they said that knowing your rights was so important on the criminal side that the U.S. Supreme Court in 1957 affirmed an Arizona State appellate court decision, and I know the judge who wrote that. He's deceased now. He died in 2008. Okay, that it was so important that you had to tell him, or else everything he said was inadmissible. Okay, that's what you have the right to remain silent, and anything you say can be used against you. The same thing applies over in civil, but nobody's done a Miranda decision yet to say that they have to tell you you have the right to a jury unless you waive your right. They're not required to tell you that. Okay, so if you ask for a jury and they say no, they're not required to tell you that, well, you can provide your own if you want. So guess what? They're never going to tell you that. They're never going to give up their own power. Okay, so it becomes our own job to understand our own rights, our own authorities over government. They do not have the final say in these cases unless you allow it. Okay, that's where my research is taken. Okay, and the people that I'm working with. Okay, so we have secret courts in Arizona. That's a violation of that's not a requirement of the federal law. That's their excuse they use for secret courts, but the federal law does not say that. Okay, and if you go to the Constitution, it says all court proceedings shall be open. That's under I think the due process clause of the Arizona State Constitution. And pretty much every state has that. You'll find it there. So if you got secret court hearings to protect the children, you know, that's just made up nonsense. Okay, that's now some states have it, some don't. And then below here, you'll see section B. It's not a big read. What is it? 2 sentences, 3 sentences? If a challenge arises from the results, let's see, let me close this here. From the results, whoops. Okay, of a bench trial, whoops, Did something wrong. I probably screwed everything up. I screw everything up a lot. Okay, so I'm going to close this.
No.
Okay.
I did it. I think I did that. Is it in the right spot?
Yeah, it's fine. So all we're saying is that for the termination hearing, there's two separate hearings. This 8-537, this is the hearing that takes place, 14 to 16 months after they take your kids. Okay, is we say we go through. First of all, there's going to be no secret trials. Okay, and then second, we say after you go through all the stuff you go through, you can have your hearing, your bench trial, and do everything that you do. We don't want to micromanage any of that stuff. Okay, but at the end of the day, if a challenge arises from the results of a bench trial and a jury demand is subsequently registered with the court shall schedule a new hearing where the evidence is presented to a jury. A unanimous verdict of a jury is necessary to permanently terminate parental rights of parent-child relationship. Okay, so just so you know, in statute, you have to specify unanimous verdict, because there's a lot of verdicts. There's a lot of statutes I've seen where it says 3 out of 4. Okay, or some states have 5 out of 11. Okay, you only have to have a majority. Okay, so we're saying that this is like a death sentence. You take people's kids away, it's a big deal. Okay, so you have to have a unanimous verdict to take their kids away. Okay, now if you scroll up, you'll look at the other law that we're dealing with at the state level, and scroll to the very top, and you will see. See, there's different ways to skin this cat. You can provide your own damn jury. Okay, we have that model. We're working that too. Okay, or you can have the state provide the jury, mandated in statute. There's nothing prohibits that. It's totally constitutional. So scroll up to A. You scroll up to A. Okay, this is the hearing that takes place within 5 to. Oh, you're on page 2 still, I think. Yeah, you're on page 2. I'm sorry. Scroll up to A on page 1. Yeah, you're on page 2. Go all the way to the top. There we go. Keep going. Aha, keep going. I like this one even better. The other A. Sorry. This is the first hearing that you get in a court, and you can see on the second line here, no more than 7 days after they take the kid. Okay, this is really the most important one. Okay, because if they're going to take your kids for no reason, you want that fixed in 5 to 7 days. You don't want to wait 18 months. That's crazy. Forget that. Okay, so there's 2 separate laws that have to be looked at. Okay, and I just learned this business in the last 2 months. Okay, because my focus has not been CPS law; it's been family law. Okay, but when the same underlying problem exists and the same underlying solution exists, well, then you're crazy not to just do fix whatever needs to be fixed and move, and then you're done. So we're doing CPS, we're doing everything. Okay. Then what we do is you scroll down to K. We let these guys do everything they normally do. We don't mess with anything. Do everything that you do. Okay. We don't care. But at the end, at the bottom, we add K. And it says, if a challenge arises to removal order under preliminary protective hearing, which is what this particular law is, conducted as a bench trial, and a jury demand is subsequently registered with the court shall schedule a new hearing where the evidence is presented to and the verdict rendered by a jury. So in other words, 5 to 7 days to have your kids, okay? And everybody, the judge, CPS, everybody knows that the final say is going to be in the hands of a jury if these guys are nuts, okay? So now, let's just say, for instance, there's a bad car wreck everybody in the family is killed except for the little kid who gets out and is walking down the street, so he's an orphan. Okay. The state picks him up and it's like, okay, everybody agrees we need to take care of that kid. Okay. When they show up and say, oh, we found dirty dishes in the sink. Oh, we have to take your kids because of the dirty dishes in the sink. You say, you know what? That's fine. Let's just go see what a jury thinks about dirty dishes in the sink. Okay. In other words, for one thing, the judge is going to throw the thing out because he knows a jury will never buy it. And then before that even happens, CPS is going to go, well, we're not taking kids for dirty dishes anymore because there's no way a judge will take it because there's no way a jury will buy it. In other words, this is about prevention. You understand? And it's about putting it in every single courtroom, regardless of whether a jury's there or not. In fact, this is going to affect cases. 99% of them never see a jury. That's how we win this thing, because we can't be in 5 million courtrooms every year. We can't do it. Okay. And our Constitution is not designed for that. It doesn't require that for a reason. They knew it was impractical. Okay. But in those cases where it's an exceptional situation, where there's obvious corruption or whatever it is, we have the final say. Okay. That's what makes this thing different than other approaches that are being used out there. Because Arizona, I'm just telling you, from 05 to 08, we had juries in every single CPS case. Okay. And it became where we had to put up 50,000 jurors every year. We had to have 50,000 people show up every year for jury duty just to service that. And our position is that the Constitution doesn't require that. And we don't want to do that. Okay, but we will have the final say if the judge goes nuts. Okay, so if the judge doesn't have the authority to make the crazy criminal decisions that he's making that everybody is mad about, and the people are going to make those decisions, then nobody has any reason to be mad at the judge or to want to throw him in jail or nothing. And the people get their kids back.
Or the people don't get their kids taken, or
exactly.
Or when they start falsifying records, doing fake drug tests, switching drug tests, all the stuff that they're doing. These are like preventative measures.
Exactly. Now you're picking up on it. This is where the light bulbs start to go on. Okay. That's why we teach everything in here. We teach everything because we need to kill this thing one way or another, or always. I say put them in the coffin and nail it shut where they can't come out. Use everything you can. Well, the fact of the matter is, and oh, by the way, we're dealing with 4 separate agencies at the federal level right now. Okay, I'm not going to disclose who all that is. There's 3 separate reporters. 2 of them are national reporters. Okay, that are following this thing in one form or another. Okay, we're close. I don't think 5 years from now we're going to be having the same discussion.
No, we're not. We're definitely close. And I got to tell you something, Martin. Nobody hates CPS and family court more than me, probably in this world. But here's the thing. I literally had an attorney on the phone with me today asking my advice how to help his client. Okay. And this is a seasoned attorney.
Gotcha.
So I have it recorded. The other thing is that when I walk into these courts now, these judges straighten up their act. Okay. So when you get to see what a court should look like, even though they're frauds and they're fake and they need to be held accountable for their actions because criminals can't judge people. That's absolutely insane. But that's another area that we're going after. But to have a court system that actually, when you see it work right, and people could walk out with a sigh of relief that justice was served, families were protected and preserved, then you've done something right. And that's what this is all about long term. We're going to need some sort of mediation at some point. I believe families should be left alone completely. But when you have criminals and crimes and danger, true risks to families, that stuff has to be remedied at some point. And also all the financial stealing, not just the stealing of children, their whole lives are taken from them, their livelihoods, their jobs, their careers, their futures, their children's colleges. It's all robbed, and there has to be accountability.
Okay, so what we're doing is, from our perspective, what we the People Court Services is doing is we're putting juries in court in these courts. We're not picky how we get them. Okay, we can either do it ourselves. We have already noticed the judges, and we're doing that right now. We can get a law passed in the state legislature. Now, you and I talked offline earlier about the courts lobbying the legislature. Okay, every time we go to our legislature, and this is pretty much nationwide. I haven't looked at a state yet where I couldn't find a court lobbyist. Okay, they go to the legislators and tell them, oh, we need to have secret proceedings for CPS to protect the children. Okay, or they'll say we need to arrest people for not paying child support and keep them in jail forever if they don't pay. Oh, that's constitutional. Okay, it sounds like a debtor's prison. Okay.
So wrong.
So in other words, before you deal with the state legislators, you got to take a crowbar and get those court lobbyists out. Okay, and the crowbar that you need is SCOTUS case law, Mistretta v. U.S. Mistretta with TTA at the end. Okay, via U.S. Okay, that defines separation of powers. Okay, and so if they, because I just got done this Monday, I was in the Rules Committee at the Arizona State House, and they said, well, the courts can do whatever they want because they have administrative power. Wow, I guess they can impose an income tax, a sales tax, use it to pay for a police force, an army, and their own prison system. Under their administrative powers, they can do anything. So then we looked at the SCOTUS case law, and Mistretta v. U.S. defines the limits of separation of powers when it comes to the judicial branch of government. This is huge, because if you can go in there and get these, I call them a tick. Okay, they're dug into our legislature like a tick, because they're so used to dealing with these people, and they're illegal. It's a violation of separation of powers for them to be there. Mistretta v. U.S. sets very narrow parameters of what the judicial branch of government can do other than decide cases. That's what judicial power is. You have the power to decide cases. And so Mistretta v. U.S. is being used. We are just it's like a baseball bat over here right now, because we got a statute in there that is outside of constitutional authority of the judges, and this thing just came up this week, and we're just hammering the hell out of them with this baseball bat called Mistretta v. U.S. So once you get these ticks, you got to pry them out of your legislature with a screwdriver. Okay. And that's what we're doing. As soon as you get those people, and then you can go in and say, oh, I want a law to put juries in CPS courts. And there's no judge there through his lobbyist to say, oh, no, we can't do that because of blah, 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 because they trust these people. They think what most people think, that you can trust what judges say. Okay, now is it misplaced? Of course it is. We know it's misplaced because we're on the business end of these monkeys. Okay, but the legislators are all being groomed and schmoozed and told how nice they are and everything. Okay, so if you want to do anything in your legislature, you got to have a look at that first, or else you're wasting your time, you're spinning your wheels. Okay, now the last item is federal. You have opportunities to put juries in these courts at the federal level. Okay, and we looked at Title 4E, and not only is Title 4E controlling, but there's rules to implement Title 4E. And so we're proposing a rule change called 81.87. Fran and I went over it earlier. And basically, all it says is that, oh, I see it. Oh, it's coming up. Oh, she's getting good here now. Okay, here we go.
Now I'm a pro.
She is. She's like an expert. Okay. So inside this box here is the proposed rule. This only requires the signature of one person. Of course, the president can do it in an executive order. And also the head of HHS, who is, I'm not sure who that person is right now, they have the authority to implement this rule by executive order in their agency. Okay, and it basically says the states have discretion to furnish the jury in all civil cases per the 7th Amendment. We've been through that. The federal government will not pay for all juries. However, in cases of suspension or severance of parental rights, which is what this section of the rules are about, is CPS, okay? Should a judge order contrary to the wishes of the parent or guardian or family or whoever, okay, that person may ask for and subsequently shall receive a new hearing decided by a jury. Jury instructions shall include parental rights or fundamental liberty interests to be interfered with by the state only under the most compelling circumstances. See, now that throws the dirty dishes in the sink out the window. It throws the basket full of laundry out the window. It throws dog poop in the backyard. Just get it out of here. Don't even bother.
It'll possibly get them to buy you a brand new dishwasher by the time you're done with them, too.
Well, you know, I like what you said earlier, which is it's preventative. Okay. Then we state the conflict of interest. The state gets $83,000 a year for every child they take. Okay. That's required to be disclosed in any other setting, is the conflict of interest before you make a decision, whatever it is. Okay. So we tell the jurors that, and then after that, the federal government shall reimburse the states for the cost of any extra hearings with a jury as described herein. This rule applies retroactively to cases in which the child has not reached the age of 17 at the time of filing for the new hearing. So in other words, if you got a 10-year-old kid that was taken 5 years ago, this thing works. Okay. Any state that fails to comply with this rule after such and such a date, whatever you want, shall have immediately forfeited their eligibility to receive any funding whatsoever under Title 4E. Then the rest is just extra stuff. Okay. So the funding hammer is there. Go ahead. Don't give them have people ask for a jury. Don't provide it. We'll give you no money. Zero. Now,
Marty, I want to read this because it's important. What is this number? 1 million children per
year
are forcibly taken from families by our government for reasons many people consider unjust. Taking away your children is more important than a traffic ticket.
Right. And then the rest of it is we the people, court services, and our disclosure, whatever it is. Okay. Because this is the product of 4 years of research. Somebody went through and studied the history of the foundation of the country. Okay.
Let me read this because Arizona is a big problem. Now, I know that this is something that can be implemented and should be in all states. Exactly. But this is Martin Lynch. It's WTPCS Phoenix office, and you can reach him at 602-550-6304. Again, that's 602-550-6304. And do you like the music in the background? That's very nice. Very nice.
It is nice. It is nice. And so just so you know, right now we're in the midst of hand-to-hand combat in the Arizona State Legislature because that's where we are in a legislative cycle right now. Okay. And we're winning. Mistretta v. U.S. is going to get these lobbyists out of our legislature, and then we could go in there and get a law passed. Because up until now, we spent 3 years trying to get anything out of the legislature, and those monkeys from the courts were in there saying, oh, no, you can't do this, you can't do that because of this reason, all these other reasons. And they don't even belong there. Okay? So those guys are on the verge of being kicked out because the Supreme Court in 1989 said the only thing you can do outside of deciding cases is you can have your probation officers make arrests if there's probable cause. Nothing else. Get back inside your courtroom, get back inside your chambers, and we'll do the political stuff belongs to other people, not you. Okay? So if we can get these lobbyists out of our legislatures, then we can go get statutes. Okay? But in the meantime, if they don't do that, we don't care. We're putting our own juries in there. Okay? And if that doesn't work, we're also going to start pushing hard this federal rule, because that's all 50 states. So, take the thing and run with it. Do whatever you want with it. Get on somebody's attention and say, if President Trump puts this in an executive order, CPS has a leash on it, because right now they don't have a leash. I think we all agree with that.
Well, they're supposed to have a leash, which is supposed to be what they call judges in the family court, which are really administrators in the private for-profit business, but they don't even do that in some states. Like in at least it's really peculiar, but in the state of New York, they have to answer to a judge's signature here. So we have some semblance of an actual court, even though it's not for real.
Well, hold on a second.
They're a little more sophisticated than some other states, so they know they can't dupe us like they do in other states, like gag orders.
This is a good point, because if you read and you've got it right up here, the rules, 45 CFR subpart H. Okay, these are the rules they have to follow, or else they get no federal money. Now you're free to open up any of those things and look at them. And if you think the state of New York or any state that you're talking about is not following it, well, you can file a complaint with the HHS and say, shut off their money. Okay, they're not following the rules. These are the rules they have to follow in order to take children. Okay, and I haven't researched every single one. All I've done is said, well, I'm going to put a rule at the end that says you can do whatever you want. We don't care, but we're going to make the final decision. If you come up with something that's crazy, we're not stuck with it. Okay, that's the only thing I care, because I don't have time to do world hunger. But this only 16 rules. Okay, so that's not anything that anybody here can't look at, and you're doing it. I can see you doing it. I'm sure there's a rule in there that says the evidence.
Here's the real important one, 81.78.
Yeah.
Irrelevant material, unreliable, and unduly repetitious evidence will be excluded.
What about the evidence that's false?
That's what this is really supposed to be covering, as well as the fact that false accusations.
Hold on a second.
Is a crime.
Is false evidence irrelevant?
I would say no.
Well, this thing here prohibits irrelevant evidence. Okay. So it doesn't prohibit false evidence. The word false isn't here. Okay. But I'm going to say false evidence is irrelevant. Well, it's a made-up story.
Irrelevant, yeah.
You're in violation of 81.78. Okay. You get no freaking money. Shut off. Call up your congressman or senator and say, go to the call up HHS or whoever and say, shut off all the money to these people. They're violating 81.78. Who do you know that's done that? I don't know anybody. I'm just saying is once you understand the landscape here, you understand all the features of the battlefield. Okay. This is a feature of the battlefield. Can't say it's not. Okay. Once you understand all these features of the battlefield, then you can decide where their weaknesses are that you want to exploit. Okay. And so that's the reason that I'm going after juries, because that's where I think they're weak. You never attack their strong points. Sun Tzu says, don't do that. Don't attack them where they're strong. Figure out where they're weak and attack them there. Okay. And the jury is, I'm just doing what Hamilton said. I'm not making anything up. I'm not fabricating nothing. The Seventh Amendment says what it says. It's there. It's not even a paragraph. It's 2 sentences. The 10th Amendment is 1 sentence. And I like I said,
what about the fact that our legislators are the true branch of the government that's supposed to be deciding on these matters, not these appointed adjudicators or administrators called judges? Like, what's the deal with that? We need to, they're supposed to change this, not say it's not their jurisdiction. They lie about it.
Well, so here's, you have to understand the nature of the problem. And I think you just described it. I'm going to try to encapsulate it into something simpler, which is unchecked judicial power. Okay. I think that's what the real root cause of all these problems that we're dealing with is that these judges can get away with anything. At least they think they can. You know, these judges that make these crazy decisions, obviously they think they can get away with it. Okay. And so if you understand the nature of the problem, then you can start to come up with rational ways of remedying the problem once you understand the problem. Okay. And so there's a lot of ways to skin a cat. Okay. And right now, because of the legislative cycle, I'm going after the lobbyists in the legislature. Then I can turn around and refocus on the actual laws, which is SB 1294, which you and I just looked at a little bit ago. The first one is the 5 to 7 day hearing, and the next one is the TPR, the termination hearing. And we're going to have juries make the final decision. I mean, the idea that one person, a judge, has the last word over one of the most important things in anybody's life, their children. Okay, it's preposterous. Is that the founding fathers leave us at the mercy of that one person when everything else they did has checks and balances everywhere, because they know that absolute power corrupts absolutely. The founding fathers never thought that. They would never even have dreamed of putting us in this position, and they didn't. They left us with the 7th Amendment, and if any one of them, if Madison or Hamilton or Jefferson or any of those people were to just appear and we showed them what we're dealing with, he said, well, we gave you the solutions right here. What are you waiting for? You know, we went and picked up rifles and fought the British Empire. We had nothing. We had no constitution. We didn't even have shoes on our feet. Okay, you guys got a constitution that says you can do whatever it is they don't do themselves. That's what the 10th Amendment says. And you need a jury to make the decision, not the judge. So what are you waiting for? I mean, after studying all these guys, what they did and why they did it, okay, I mean, it really is pretty clear.
Well, you're going to find this interesting. It goes well with what you're showing. Let me just find the right spot. I spoke before the legislators this is actually done in 2015. I called it the pink elephant in the room, and I just spoke of the pink elephant in the room again I think it was yesterday. That's the one that banned me from Facebook for 30 days. But anyway, let me just show you this because it goes very well with what you're talking about.
Okay.
I think you'll applaud. Hold on a minute. Let me just find my spot.
Well, I'm just going to reemphasize what Fran said. She said that the biggest impact that this particular model has on the courts is prevention. Number one, they don't take your kids in the first place. Number two, if they do take your kids, you get them back straight away. Okay. Unless there's some kind of real live reasons where those kids need to be taken care of. They're being beaten up, their arms broken, they've got black eyes, all this kind of stuff. We all agree that we need to do something. Okay.
Yeah, but what we don't need is to take them from full families. The whole entire family.
Correct.
The blood biological. Let me just let me move it to where it starts, which I believe is right there. Okay, hang on. Because I want you to watch one person. I'm going to circle him. And he does everything wrong in the court, but watch him nod away at everything I say. Just watch.
Amato-Banfield, and last year in August, I became a chapter leader for
Tri-State Coalition for Family Court and CPS Reform, the New York chapter. We're in Connecticut and we're in New Jersey as well. And there's a video which will show you that you guys can refer to. It's a little over an hour to give you a little more information. I don't have that much time. Excuse me a second. So I'm the Tri-State Coalition leader for Ulster County, and we have a huge and ignored giant elephant in the room. As I look in this room, as I know the victims, I see represented here victims of Ulster County Family Court abuses by judges. I am privy to hundreds of cases in Ulster County that I look at practically daily and with tears in my eyes, day in and day out, because victims call me morning, noon, and night now. And from all different counties, but specifically my target area is here. Unbelievable how this is getting overlooked. And we are demanding transparency, accountability for these courtrooms. I'm informing the people today that we are growing in leaps and bounds because of the neglectful family court and CPS system. We have discovered that victims of family abuse are far and wide. Therefore, we are appointing a county chapter leader in every county in New York. We are not thinking inside the box because the box is not working. We don't care about theories, judicial immunity or not. We will be suing numerous judges, attorneys, litigants, clerks that abuse power, steal taxpayers' money, have innocent parents use all their assets, lose work, and the like. We are in process now of a huge federal lawsuit. It's being done in New Jersey with the New Jersey Tri-State Coalition for Family Court Reform and already has been accepted federally. Primarily, this is a revolution of parents who won't take it anymore. We didn't get the help we need, so we're taking it. It is being, we will not allow our God-given parental rights to be court bullied any longer. Most of you did not even have, most of us, did not even have due process. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws. Some of these people, myself, and the hundreds that we work with, have had their children taken based on false allegations or hearsay, or old past behavior that has proven to be no longer existing. Chapter 11, that due process is a term with a precise technical import going back to the Magna Carta. It means that a person's life, liberty, or property can't be taken away from them except by judgment of his peers pursuant to a fair trial. I will prove now how God not only gave us these rights, but it is enforced in our laws here in America. Parental rights are unalienable and come from God, the Declaration of our Independence. They are among the retained rights of the people, 9th Amendment. Parental rights do not come from the 14th Amendment. The Declaration of Independence does not delegate powers to federal courts. It is the federal Constitution which delegates powers to the federal courts. It is for state legislators and candidates for that office to argue that the state has no power to interfere with parents' God-given authority over the rearing of their children and to act accordingly. The people need to elect state legislators who understand that the state may not properly infringe God-given parental rights. I got mocked in court because I spoke of protecting my son and it was my God-given right. I got mocked in court. He did a song and dance, the attorney. The federal Constitution does not authorize judges to come up with their own list of what rights people have for and use their list to overturn state statutes. The federal Constitution does not mention parental rights. Such cases do not arise under the Constitution, so federal courts have no judicial power over such cases. So therefore, judicial immunity or no judicial immunity, whichever way you interpret it, we all know it's a crime to allow anyone, despite their position, despite their position, especially a judge, who should be held at a higher accountability to be immune from the crimes of decisions that are endangering the welfare and safety of our children. Now watch him right here that I'm circling. Watch him carefully.
Okay, this is what you just read?
Yes. He's an attorney and a legislator. I'm going to speak for one of our victims' mother here. Her name is Lindsay. She actually signed up and is yielding her time. She will break down and she will not be able to finish. So one of my constituents and just for a second, the judge I'm speaking of also violated this woman's rights and numerous families throughout the years. the one that previously spoke as well, like for 15 years prior, and he's still on the bench. He's the one that retaliated against me and took my son for almost 8 months, in which I won back. And now we're in 2 federal lawsuits. Well, we're actually in one at the Court of Appeals and one that is moving smoothly under the ADA, just so you guys are aware. We've done a lot, and now it's 2019, and I'll be speaking there again on the 16th, and I'm not going to be as nice as I was this time.
Victim of Ulster County Family Court, and I know I can't say the judge, but it's one of the judges there, has an impeccable background. She is in the court, and too destroyed to speak. He's destroyed her life, literally destroyed her life. She is a veteran, a marathon runner, and has never had any sort of drug or alcohol history or issue with the law. She was the primary caretaker and appreciated as such by her estranged husband for the duration of his first child, 1 decade. Suddenly, after an abusive marriage, when she left, her estranged husband, who had the same judge and the same law guardian, who I can't say, for custody with previous mother of first child, basically she has to have them recused, and they refused, and it continued to go on, and she lost her children.
So let me pause again, because he nodded as if they know, because they all know who this judge is, but they're all crazy, but some of them are a little more crazy than others. The woman I'm speaking of, she was married to a man who abused his first wife, and she was the second wife. She was good enough to watch his first child for 10 years. She was perfectly sane until she left him. When she left him, she was no longer considered sane by him. So he ended up with custody of all the children somehow through the same judge and the same law guardian. Same judge, same law guardian with first wife, same judge, same law guardian with second wife. Both women got no children. The father got them completely. There's no 50-50, completely. And this is what he'll do if there's abuse. Now, on the flip side, I have fathers who don't get anywhere near their children because the women will give them Ritalin and different kinds of psychotropic medications and let them go through the CPS system. So he'll keep them with them. So it's like, you have to see the whole dynamic, how it works, because I court watch him all the time. Not just him, obviously, others. But it's interesting to see how he seems to have a more of a hatred towards women and children, but he will go after kind, good fathers, and he'll eat them up in court.
She lost her 3 beautiful children. They forced her to be supervised. She never sees them. Her brother died, and her abusive addiction, DWI proven record ex-husband. Basically what has happened is he's got the rights, but because his family has a lot of money, and he's a drug addict and an alcoholic who gets into car accidents and continues to have the 3 children who I've supervised for children to keep an eye on things. And we court watch. We know what's going on throughout this entire system. And basically, her children are crying. They want their mother. They cling to her. I have to go in the bathroom to cry because it's a horrible thing. And I see this day in and day out. It's not gender bias, by the way, because it happens to males too. Many, many fathers we get that as well. It seems to be criminal and drug addict and abuser friendly. That's what it seems to be. And it keeps us in the courts in a rotating cycle to keep going back because it's taking taxpayers' money and it's making money because there's definitely something going on with finances that are keeping us in a rotating door in family court. And then CPS gets involved because that's part of the plan to keep people going and going and going and fighting for their children. Because what are you going to fight for in this life more than anything in this world?
Now watch him.
This has touched your heart in such a way that you make haste to make some changes because we need accountability in there immediately. We need accountability in CPS. We need oversight, and we need a jury in these courtrooms. It's not fair to have one judge make all the decisions. Thank you very much.
See him nodding with the "we need a jury"? So he agrees. We need a jury in these courtrooms because it's not fair to have one judge make all these decisions. Now that was, just so you guys see, this was the Ulster County Legislator, October 20th, 2015. That was back in 2015. Sorry, it kind of moved along there. So this was really a good topic tonight. I'm just gonna have you keep talking, Martin, but I'm going to turn off the YouTube. So again, if anybody wants to reach Martin, can you just say again how they can reach you before I close out the live?
602-550-6304. If I don't pick up, just leave a message. I sleep weird hours.
Okay.
I'll work on something until I'm done. Last night I sent something over to the legislature. I didn't get done sending it to everybody until 5 a.m.
I know the story, believe me. They're doing this nationally, I know. All right,
So
well,
then-
thank you for watching this tonight, everyone that's watching this on live stream. You can reach us at punish4beingaparent.com, punish4beingaparent.com in order to get into our amazing boot camp classes. Thank you.